All right, welcome back to the deep dive. So you know how this works. You send us the stuff you're trying to get your head around, and we we extract the absolute key knowledge from it.
Exactly, like an intellectual juicer, if you will.
Exactly. Love that. So today we're diving deep into something pretty massive, the EU's AI Act. And for this one, we're going off that, the AI Act Road to Compliance Final-1-PDF document you sent over.
Yeah, and our goal here is to give you a super clear picture of what this act actually means for folks like you, especially if you're involved in internal audit or if your organization is working with AI in the EU, right?
I mean, this thing is, it's dense, to say the least. So we're going to break it down into what matters most. We'll start with, like the big why behind this whole act, like why is it even happening? And then we'll get into the actual nuts and bolts of it, the timeline, like when different parts kick in, and those key obligations that it puts on everyone.
And then to wrap things up, we'll take a look at some pretty interesting findings from a recent survey that looked at how organizations are actually handling AI and audit right now. What are people actually doing on the ground? So where do we even begin with this thing?
Well, I mean, it's pretty clear that the EU AI Act is like a direct response to how fast AI is becoming part of, everything, right? Like both public and private sectors are using it more and more.
Oh, absolutely. And, it's only picking up speed, this rapid integration. It's kind of natural that it raises some, eyebrows, some questions about the potential risks.
Right.
And that's where the AI Act steps in. I mean, with it coming into force in August 2024 and this phased implementation, it really shows how seriously the EU is taking this whole technological shift, They want to make sure things are done right.
So, like, at its core, at its heart, what is the AI Act really trying to get at? What's the mission here?
Well, at its essence, the Act has these two main objectives. First, and I think most importantly, it's all about protecting those fundamental rights and personal data within the EU.
Okay. Yeah, makes sense.
But at the same time, they also want to encourage innovation, right? Build trust in AI technologies within the European market. You can't just stifle innovation. You have to kind of guide it in the right direction.
Right.
And what I find really interesting here is the strong focus on these what I call ethical considerations. It's not just about data privacy. It's about making sure AI is developed and used in a way that respects things like non-discrimination, equality, and even cultural diversity.
Makes a lot of sense. Now, one thing I'm curious about, when we say AI, when the Act says AI, what are we actually talking about? Like, these days, it feels like AI can mean a lot of different things to different people.
That's a good point. And the Act actually provides a pretty specific definition. It defines AI as, and I'm just going to read this straight out, a machine-based system designed to operate with varying levels of autonomy that may exhibit adaptiveness after deployment, and that, for explicit or implicit objectives, infers, from the input it receives, how to generate outputs, such as predictions, content, recommendations, or decisions that can influence physical or virtual environments.
Okay, so let's unpack that a bit. So it says varying levels of autonomy. So that means it's not just talking about systems that like follow a bunch of rules, like a set of instructions without any flexibility.
Exactly. That's the key difference here. If a system is just rigidly programmed, following those preset rules, it probably wouldn't be classified as AI under this act. The real distinction is this idea of infers.
Yeah, it talks about generating outputs, predictions, decisions, all that, which, I mean, on the surface, that seems obvious, right? But the inferring part is where it gets interesting.
Right, because it's not just about processing data. It's about the system actually drawing conclusions from that data, generating outputs that can have real-world impacts, whether it's in the physical world or the digital one.
And that's what really struck me about this definition, just how wide-ranging it is.
Yeah.
Like predictions, content, recommendations, decisions that can influence. That's a lot of ground to cover.
Yeah, you're spot on about that. And the way I see it, the definition is intentionally broad. It's designed to anticipate future developments in AI that we might not even be able to imagine right now.
Right. Future-proof it.
Exactly. But this broadness also presents a real challenge for organizations. I mean, internal auditors in particular are going to have to be super careful in understanding how their organizations are interpreting this definition consistently, across different departments, different applications. It can't be a case of one department doing it one way and another doing it differently.
Yeah, that makes sense. It's going to require some careful thought. Now, the Act also talks a lot about risk, right? This whole risk-based approach. Can you explain how that works?
Yeah, the risk-based approach is really at the core of this whole thing, at the core of the AI Act. It basically categorizes AI systems into four main levels of risk, and the obligations that organizations face are directly tied to that classification. So, starting at the top, the highest level of risk, we have unacceptable risk. These are AI systems that are flat out prohibited because they're considered to violate those fundamental EU rights and values we were talking about.
Unacceptable risk. So what kind of AI would fall under that? Can you give us some examples?
So think about AI that's used to manipulate people in ways that could cause, serious harm, like AI systems that are used for indiscriminate profiling or creating those facial recognition databases that have raised so many privacy concerns. Then there's AI that's used to try to infer emotions in general contexts. There are some very limited exceptions here, like for specific medical or safety purposes, but for the most part, that's a no-go. And then, of course, there's the use of real-time remote biometric identification in public spaces, like on the streets. That's also prohibited under the Act. And, if you really want to get into the nitty-gritty, Article 5 of the Act has the full definitive list.
Okay, so unacceptable risk is off the table completely. What's the next level down?
So the next level is high-risk AI systems. These aren't banned outright, but they do have the potential to cause significant harm to individuals' health, safety, or fundamental rights.
Okay, that sounds pretty serious too. What are some of the things that would be considered high risk?
Well, there are a lot of examples here. Think about AI that's used as a safety component in critical infrastructure, like in power grids or transportation networks. If those AI systems fail, the consequences could be really severe. Then you have things like biometric identification and categorization systems and AI systems that are used in areas like education, employment, worker management, even law enforcement and migration and asylum processes. And of course, any AI that could influence things like democratic processes, like elections, or AI that's used to make decisions about access to essential services like insurance, creditworthiness, or public assistance, those are all high risk as well.
Oh, okay. So that's a pretty wide range of applications. And I imagine those high-risk AI systems come with, a lot of strings attached, a lot of requirements.
Oh, yeah, you're not kidding. The requirements for high-risk AI, they're pretty extensive. We'll dive into those a bit more later. But yeah, organizations are going to need to start thinking about this stuff now if they want to be ready.
Okay, so unacceptable is banned. High risk comes with a lot of obligations. What about the lower risk categories?
So below high risk, we have limited risk AI systems. These are things like chatbots or those AI content generation tools that are getting so popular now, the ones that can generate text or images.
Right.
Now, the main requirement for limited risk AI is transparency. It's all about making sure that users are aware that they're interacting with an AI system. Like a chatbot should clearly identify itself as a chatbot, no trying to trick people into thinking they're talking to a human.
Right, transparency is key. And then the final category, the lowest risk.
Yeah, the lowest risk category is minimal risk. This covers things like AI-enabled video games or spam filters. For these types of AI, the Act basically says, hey, no worries, no specific requirements here.
Okay, so it's a sliding scale of risk, and the obligations kind of, correspond to that. Now, you also mentioned something earlier about a separate category for, general purpose AI?
Yes, general purpose AI, or GPAI.
Right, GPAI. Can you explain what that is?
So GPAI is basically referring to these large AI models that are trained on huge amounts of data. The kind of models that can be used for a wide range of tasks. They're kind of like the foundation for a lot of other AI applications, like those chatbots or content generators we were just talking about.
Okay, so it's kind of like the underlying AI engine, the brains behind a lot of other AI stuff.
Exactly. And the Act recognizes that these foundational models need some special attention. Now, the requirements for GPAI models can get even stricter if they're considered to have systemic risk.
Systemic risk, what does that mean in this context?
So there are a couple of ways a GPAI model can be classified as having systemic risk. One is based on the amount of computing power that was used to train it. If it was trained using more than 10 to the power of 25 FLOPs, it's automatically considered systemic risk.
Wow, that's a lot of computing power.
Yeah, it is. But the other way a GPAI model can be classified as systemic risk is if the European Commission determines that it has equivalent capabilities or impact even if it wasn't trained with that same level of computing power. It's kind of like saying, hey, even if this model isn't super computationally intensive, it could still have really widespread effects because of what it's used for, you know?
Right, like the application matters just as much as the underlying technology.
Exactly. And even for those GPI models that don't reach that level of systemic risk, there are still transparency requirements in place. The EU wants to make sure there's always a clear understanding of how these powerful AI models are being used.
Okay, so we've got the context, the definition of AI, this risk-based framework, and the fact that GPI gets some extra attention. The document also talks about these different roles in the AI ecosystem. Like, who are the key players here?
Yeah, the Act identifies a few key players, and their responsibilities can differ quite a bit. So first, you have the provider. This is usually the company or individual who actually develops the AI system or GPAI model and puts it out there on the EU market.
Okay, so they're the ones, like, creating the AI, making it available.
Exactly. And whether they're based in the EU or outside of it, providers have the most extensive compliance responsibilities. Now, if a provider happens to be based outside of the EU, they might use an importer or a distributor to actually make their AI available within the EU market. It's kind of like having a local representative to handle the logistics.
Makes sense.
Yeah.
And then who is actually using the AI in practice, like in their day-to-day operations?
That's where the deployer comes in. This is the organization that's actually using the AI system. You know, maybe they're using it for their employees or offering it as a service to their customers. Now, deployers have fewer direct obligations than providers, but they're still responsible for making sure they use the AI properly, you know, according to the provider's instructions. And then lastly, for those providers based outside the EU, there's this role of the authorized representative.
Okay, and what do they do?
Basically, this is a person or entity that's actually based in the EU, and they're designated by the non-EU provider to kind of act on their behalf. It's like having a point of contact within the EU for all those regulatory bodies and, you know, even for consumers if they have any questions or concerns.
So it sounds like one organization could actually wear multiple hats, you know, could have multiple roles depending on the AI systems they're involved with.
Oh, absolutely. And that's something that internal auditors really need to keep in mind. You could have an organization that's a deployer for one AI system they're using internally, but then they could also be a provider if they happen to develop their own AI-powered product and make it available to others in the EU market.
Right, so their role can shift depending on the specific AI system.
Exactly. And even more than that, these roles can actually change over time. Like a deployer might become a provider if they make some big changes to an existing AI system or if they decide to like rebrand it under their own name. And when those roles shift, well, the compliance requirements shift right along with them.
Okay, so it's definitely not like a static situation. It can be pretty dynamic.
Definitely not static. And that just adds another layer of complexity for internal audit to consider.
Okay, so we've got the context, the definition of AI, the risk-based framework, and all these different players. Now, let's talk about when all of this actually goes into effect. What's the timeline here for compliance?
So the AI Act, it's not just like an overnight thing. It's being rolled out in phases. It officially entered into force on August 1st, 2024.
Okay, so that's when it became like legally binding.
Exactly. But the first big deadline that organizations need to be aware of is February 2nd, 2025. This is when those regulations about those prohibited AI systems we talked about, those unacceptable risk ones, that's when those start to actually apply.
Okay, so by early 2025, those really risky AI systems should be like gone from the EU market.
Right. That's the goal. And this first phase, it's really about raising awareness, making sure organizations understand what's off limits and are taking steps to like stop using or offering those unacceptable risk AI systems.
So organizations should be like actively taking stock of their AI systems, figuring out where they fall in terms of risk.
Exactly. They need to be creating those internal inventories, classifying their AI systems based on the Act's criteria, and starting to develop those internal policies to make sure they're ready. No more kicking the can down the road on this.
Right, right. So what's next on the timeline after those prohibited systems are dealt with?
So the next major date to keep in mind is August 2nd, 2025. This is when those specific rules about GPAI models come into play, and it's also when those general governance and enforcement mechanisms of the Act kick in.
Okay, so GPAI gets its own special attention.
It does. And in particular, those providers of GPAI models that are considered to have systemic risk, they're going to have some extra obligations. They'll need to notify the European Commission, let them know they're working with these potentially high-impact models.
Yeah, keep them in the loop.
And they also need to have, really robust compliance policies in place. They can't just be winging it. And on top of that, both deployers and providers will need to have transparency mechanisms in place for their GPAI systems. It's all about making sure that there's a clear understanding of how these models are being used and what their potential impacts might be.
So GPAI is a big focus in 2025. What about the more general requirements for all those other types of AI systems? When do those come into effect?
So the vast majority of the AI Act's provisions, with just one little exception, they all become applicable on August 2nd, 2026.
Okay, so that's like the main compliance deadline.
It is. And by that point, organizations really need to have their ducks in a row. They need to have all their policies and procedures in place for all those identified AI systems, regardless of the risk level. For those high-risk AI systems, providers and deployers both need to have those risk assessment, risk management, and accountability systems up and running. No more excuses. And even for those limited risk systems, like those chatbots, providers and deployers need to have their transparency policies implemented. It's all about making sure everyone is on the same page and that everything is clearly communicated.
Okay, so August 2026 is a big one. And you said there was one little exception, one part of the act that comes into effect even later.
Yeah, there's one specific article, Article 6.1, that doesn't kick in until August 2nd, 2027. This one's all about the high-risk classification of products that have those AI safety components like the ones we talked about in critical infrastructure.
Right.
And by that point, all those GPAI measures that came into effect in 2025, they'll apply to all GPAI systems out there, no matter when they were initially put on the market. So even those pre-existing GPAI models will need to be fully compliant by August 2027. No more grandfathering in after that. And of course, any provider of a product with AI components that falls under Article 6.1, they'll need to make sure they meet all those obligations for high-risk AI systems. It's like a final deadline to make sure everyone's fully on board with the Act's requirements.
Okay, so lots of dates to keep track of, but the key takeaway is that this is a phased implementation, and organizations need to be actively preparing now.
Absolutely. No time for procrastination on this one.
So let's dig a little deeper into what those obligations actually look like, depending on, the risk level of the AI and the role of the organization. Where do we even begin with this?
Well, a good place to start is with those general obligations that apply across all the different risk levels.
Okay, so these are like the baseline requirements. Everyone needs to do this stuff.
Exactly. So first up, there's this requirement for what they call AI literacy. Basically, organizations need to make sure that everyone who's involved in operating or using AI systems, they need to have a decent level of understanding of, what AI actually is, how it works, and what the potential implications are. It's not just about the tech people, it's about everyone who might come into contact with these systems.
Right, so it's about building awareness and understanding across the organization.
Exactly. And then there's this requirement to create what they call an internal AI registry. This is basically where organizations need to document all those AI systems they're using or making available to others, like a comprehensive inventory.
So no more shadow AI, no systems flying under the radar.
Exactly. Everything needs to be accounted for. And closely tied to this is the need for a really thorough AI risk assessment.
Okay, so once they've got that inventory, they need to actually assess the risk of each system.
Exactly. And this isn't just any old risk assessment. It needs to be done according to the specific risk classification criteria outlined in the Act itself. It's not a general risk analysis. It's specifically about determining where each AI system falls in terms of those 4 risk categories we discussed: unacceptable, high, limited, and minimal risk.
Right. It's about applying the Act's framework consistently.
Yeah.
So what about those unacceptable risk AI systems? We know they're banned, but is there anything else organizations need to do?
Well, the main obligation there is pretty straightforward. They just can't be put on the EU market, period.
Okay, so that one's pretty clear cut. Let's move on to those high-risk AI systems, the ones that come with those extensive requirements.
Yeah.
For the providers of those systems, this is where it seems like things get really, really complicated.
Oh, yeah. For providers of high-risk AI, it gets pretty intense. There are a lot of boxes to check. So first of all, they need to establish a really comprehensive risk management system. And it can't just be like a document on a shelf. It needs to be actively implemented, documented, maintained, the whole 9 yards. And it needs to cover the entire life cycle of that AI system, from development all the way through to deployment and even beyond. It's about thinking ahead, anticipating those potential risks, and having plans in place to mitigate them.
So it's about proactive risk management, not just reacting to problems after they occur.
Exactly. And then there's the whole issue of data. Data quality and governance are absolutely critical for high-risk AI systems. Providers need to make sure that the data they're using to train, validate, and test those systems, it needs to be of high quality, and they need to be thinking about those potential biases that could creep in. Garbage in, garbage out, as they say.
Right, the quality of the AI depends on the quality of the data it's trained on.
Makes sense. Absolutely. And before that high-risk AI system even sees the light of day, providers need to create super detailed technical documentation. This is like their instruction manual. And the Act actually specifies exactly what needs to be included. It's all about transparency and making sure that anyone who needs to understand how that system works can actually do so.
So good documentation is essential. What else is on the checklist for high-risk AI providers?
Well, they also need to have really good record-keeping practices in place. This means keeping detailed logs of all those key events and decisions related to the AI system. It's all about traceability, being able to go back and see what happened, when, and why.
Like an audit trail for the AI.
Exactly. And they also need to be really good at communicating with those deployers, the people who will actually be using those AI systems. They need to provide them with all the information they need to use the AI properly, safely, and ethically. It's not just about handing over the technology. It's about making sure it's used responsibly.
Right, so transparency and clear communication are crucial.
Absolutely. And then, of course, the design of these high-risk AI systems needs to incorporate human oversight capabilities. It can't just be a case of set it and forget it. There needs to be a way for humans to monitor what's going on and intervene as necessary.
Right, so keeping humans in the loop, even with these highly automated systems.
Exactly. And those high-risk systems also need to meet really high standards for accuracy, robustness, and cybersecurity. They need to be reliable, they need to be able to handle unexpected inputs or changing conditions without falling apart, and they need to be secure against those malicious attacks.
So it's not just about functionality, it's about making sure those high-risk AI systems are really well built and secure.
Exactly. And the list goes on. Providers also need to establish a quality management system to make sure they're staying on top of all those AI Act requirements. It's like a system for checking their own work, making sure everything is up to snuff.
Okay, so it's like a system for ensuring compliance within the organization.
Exactly. And they need to keep all that documentation, all those technical documents, quality management system records, those declarations of conformity. They need to hold on to all that for at least 10 years.
Wow, 10 years. That's a long time.
It is. And those automatically generated logs, they need to be kept for at least 6 months, unless there are specific rules that say otherwise. It's all about making sure there's a paper trail, a digital trail, whatever you want to call it, so that if there are any issues, they can be traced back and investigated.
Makes sense. So what happens if a provider, realizes that their AI system doesn't actually comply with the Act? They find a problem, what do they do?
Well, if they find a nonconformity, they're obligated to take corrective action. They need to fix the problem and provide all the necessary information to the relevant authorities. They can't just sweep it under the rug.
Right, so transparency and accountability even when things go wrong.
Exactly. And they also need to cooperate with those competent authorities. If those regulators come knocking, they need to be open and willing to show that they're doing everything they're supposed to be doing.
Okay, so lots of responsibility on the providers.
Yeah.
Now, what about those providers who are based outside of the EU? What do they need to do?
So for those non-EU providers, they need to formally appoint that authorized representative we talked about earlier. This person or entity, they need to be based in the EU, and they're basically the provider's point of contact for all those EU regulatory matters.
So it's like having a local representative to handle all those EU compliance issues.
Exactly. And it's not just about communication. That authorized representative actually has to do a conformity check to make sure that everything's in order. They need to verify that the declaration of conformity is accurate, that the technical documentation is complete, and that the right kind of conformity assessment has been carried out. They're like a second set of eyes, making sure that the non-EU provider is playing by the EU's rules.
Okay, so lots of hoops to jump through for those high-risk AI providers. Now, how do they actually prove that their AI systems meet all these requirements? What's the process for demonstrating compliance?
So to demonstrate compliance, providers of high-risk AI systems have to go through what's called a conformity assessment.
Okay, and what does that involve?
Well, there are a couple ways this can be done. Sometimes it's based on the provider's own internal controls and processes. They basically demonstrate that their own internal systems are robust enough to ensure compliance. But other times it involves getting a third party involved, what they call a notified body.
A notified body, what's that?
Basically, it's an independent organization that's been authorized by the EU to assess conformity with the Act. They come in, they take a look at the provider's quality management system, they review the technical documentation, and they make a judgment call on whether the AI system meets the requirements. It's kind of like an external audit to verify compliance.
Okay, so it's like getting a stamp of approval from an independent expert.
Exactly. And once that conformity assessment is done, the provider has to draw up a formal document called an EU Declaration of Conformity. This is their way of saying, hey, we've done our due diligence. This AI system meets all the applicable requirements. It's basically their legal statement that the system is compliant and they're taking full responsibility for it.
So it's like signing on the dotted line, taking ownership of compliance.
Exactly. And to make it super official, they also need to put the CE marking on the AI system. This is that little logo you see on a lot of products sold in the EU, and it indicates that the product meets all the relevant safety and compliance standards. In this case, it means the AI system meets the AI Act's requirements. And then before they can actually put that high-risk AI system on the market, they need to register it in the EU database. It's like a central repository where all those high-risk AI systems are tracked and monitored.
So it's all about transparency and making sure that there's a clear record of what's out there.
Exactly. And for those providers who are based outside the EU, their authorized representative, they also have a role to play in this whole process. They need to do that conformity check we talked about to make sure that everything's in order, and they need to make sure that the AI system is registered in the database. It's all about shared responsibility for compliance.
Okay, so we've covered a lot of ground on those high-risk AI systems. What about the deployers, the people actually using those systems? What are their responsibilities?
So the obligations for deployers, they're not quite as extensive as for providers, but they're still really important. The main thing is that deployers need to make sure they're using that AI system responsibly, according to the instructions that the provider gave them. They can't just go rogue and start using it for things it wasn't designed for.
Right. So it's about using the AI as intended within its limits.
Exactly. And they also need to make sure there's some level of human oversight in place. It's not just about letting the AI run wild. Someone needs to be keeping an eye on things, making sure it's operating as expected, and stepping in if there are any problems.
So again, it's about keeping humans in the loop.
Exactly. And deployers also need to make sure that the people responsible for that oversight, they have the right skills, the right training, and the authority to actually do their job effectively. It can't just be anyone. They need to understand the AI system and how to manage it properly. And then, of course, deployers are also responsible for the data that they're feeding into the AI system. They need to make sure that the data is relevant, that it's of good quality, and that it's being handled in a way that complies with all those data protection regulations.
Right. So data quality and governance are important for both providers and deployers.
Absolutely. And finally, deployers need to actually monitor how that AI system is operating. They need to be tracking its performance, looking for any red flags, and making sure it's still doing what it's supposed to be doing. If something seems off, they need to investigate and take action.
So it's about ongoing monitoring and management, not just a one-time setup.
Exactly. It's about being proactive and vigilant throughout the life cycle of that AI system.
Okay, so lots to think about for deployers of high-risk AI systems.
Yeah.
What about those lower risk categories, like those limited risk AI systems, those chatbots we talked about earlier? What are the obligations there?
So for limited risk AI systems, it really boils down to transparency. Providers need to make it crystal clear to users that they're interacting with an AI system. No hiding behind the curtain, no trying to pass the AI off as a human.
Right, so no more pretending that the chatbot is actually a friendly customer service rep named, Sarah or John.
Exactly. Users have a right to know they're dealing with an AI, and providers need to make that clear up front. And then there's this additional requirement for both providers and deployers of GPAI models, even those that aren't considered high risk.
Okay, what's that?
Basically, any output that's generated by that GPAI model, whether it's audio, image, video, or text, it needs to have a machine-readable marking that clearly says, hey, this was made by an AI, no passing off AI-generated content as human-made.
So like a digital watermark that says AI-generated.
Exactly. It's all about transparency and making sure that people understand the origin of the content they're consuming.
Okay, so transparency is key for limited risk AI and GPAI models. And what about those minimal risk AI systems, like those spam filters we talked about? Any requirements there?
Nope. For minimal risk AI, the Act basically says you're good. No specific requirements here.
Okay, so they get a pass. They're low risk enough that they don't need any extra oversight.
Exactly. Now, just to recap, we also talked about those specific obligations for general purpose AI models.
Right, right. Can you just go over those one more time?
So for all GPAI models, regardless of their risk level, providers have those transparency obligations. Just like with limited risk AI, they need to tell users they're interacting with AI, and they need to mark those AI-generated outputs.
Right, so that part's consistent across the board.
Exactly. But for those GPAI models that are considered to have systemic risk, the requirements get a lot heavier. They need to classify their models, let the European Commission know about them, provide all that detailed technical documentation, respect copyright laws, do those thorough model evaluations and adversarial testing, and really think about those systemic risks and how to mitigate them. They also need to report any serious incidents to the AI office and make sure their systems are secure against cyber attacks.